बोला तो नहीं मुझे खाने के लिए तो स्टार्ट करना है मैं जब 4 बजने तो
Gupta sir, you can start the webinar.
Good evening, friends. I am your host, KK Gupta. We welcome all the delegates, all the members, bankers, and my friends on this important webinar of challenging in liquidations of the corporate entity under Insolvency Code 2016. At the outset, I express my gratitude toward the members, toward the bankers, who understand that I was not feeling well last 1 year, 1 month. They telephoned me and also inquiring for about my health. With your blessing, I am okay and I am interacting with you after a 1 month period. You are aware that this IVC, when we are talking about the IVC, we are talking about the Insolvency Bankruptcy Code. We are not talking about the rules or we are not talking about the acts. Because so many acts, so many information merge into one single law. What was the necessity to have such law? Because you are aware, in 1991, when liberalizations, you can say globalizations, and at the time, macroeconomic crisis was there. Based on liberalizations, we are talking about the privatizations, and we are talking about the globalizations model. It was invited all the global players to come to India with technology, with the money, so that our economy can be progress. You are also aware that in 2009, the competition amendments ordinance come under which the interest of the consumers were protected. And for the mitigation of the foreign investment and technology, industrial productions, this act was amended. Trade and the participants has given the freedom to have a trade in India. Now, main question was there. You have invited the person, you have given a competitions. Main was the exit route. What was the exit route in there? So, in view of that, in 2016, right to exist was there in the shape of what we are talking about, Insolvency Bankruptcy Code was introduced. With this, when you see the ease of doing business, which was ranking 142 in the year 2014, come to 63 in 2022. You see that by enactment of the IBC or other facility being provided to the foreign investor, how the ease of doing business, our ranking When we are talking about a ranking of 190 countries, our ranking at present is 63. You see the positions. Now, question is IBC. We are talking about the IBC. What is insolvency? We are talking about incapable to repay the dues. That is insolvent. When we are talking about the bankruptcy, it is unable to pay. That means incapable and unable to pay. When party is unable to pay, definitely the banker, even the party can go to the NCLT. There were the regulators like IBBI. They're talking about the insolvency resolution agency, insolvency professionals, and information utility. When we are talking about educators, that is NCTL, NCLT, and we are talking about the TRT. These are the aspects we are talking about. Now, main subject is liquidations. Why the under company is going for a litigation, for liquidations? Liquidation is a process where the debt laden companies which are unable to pay the legitimate dues of the lenders, creditors, they declare themselves as insolvent. And by selling the assets, they repay the loans. Now, major aspect is when we are talking about the December 16 to March 22, we are only having 14% of the total cases filed having a resolution plan accepted. That means most of the cases, when we are talking about the 47% of the cases which was filed coming under the liquidations. That means what are the challenges for liquidations? That is the most important aspect which we want to discuss here. We also want to discuss the time framework as per CRP. Time framework is 180 plus 90 days. When we are finding out the past data, so it was 4.3 years in 2017, which stand reduced to 460 days in 2021. That means we are far away from the non-fixed for 180 days and 90 days. We are going to discuss these detailed aspects. Major aspect is also for liquidation is haircut. Haircut is in certain cases, it is very, very high. So that we are also going to discuss. There is a mismatch between the quoted value, you can say bid price, and the insolvency value, what we are calculating, that we are going to discuss. These are the major aspects. We are also going to discuss how much recovery was made during this period. As per data available with us, it is 7 trillion amount was filed, wherever the recovery was 2.5 trillion. That you can find out about 36% of the recovery was made under the system. When we are talking about the World Bank, so it appears that we have recovery aspect in respect of the IBC is very, very thin, and haircut is very high. What are the opinion of the World Bank? World Bank says, highlight it. India is by far the best performer in South Asia on resolving insolvency. These are the finding of the World Bank. So I am not taking much time here. So we are going to discuss in details about the streamlining liquidation of the corporate entity. We are also discussing the massive haircut and delay in sale assets raising in term finance, and challenges faced by the selling business in one place that we are going to discuss. We are eminent personality with us. We are having Shri Arvind sir, who is chartered accountant. We are having Shri Ashok Kumar Gupta, managing director, professional advisor LLP, and we are having advocate Satyendra sir. So first of all, I am requesting Shri Ashok Kumar Gupta, managing director, professional LLP. He is a drafted compliance certificate and timeline under liquidation regulations, solutions for various issue under CRP. So he's the best person. He's gold medalist in MBA from Indian Institute of Foreign Trade. And he has a vast experience under the various fields. Either you're talking about he participating in various training program and education program and cyber and crime frauds, etc. So I'm asking Mr. Gupta, major aspect what we are feeling is how is streamlining liquidation of a corporate entity. How you can streamline. This is the most important aspect. Streamline liquidations. Because our rules, regulation are there, section are there, how to liquidate, that is also there. Lekin as per view, you are the expert in this field. So what do you feel that, how it can be streamlined? I hand over to Mr. Ashok Gupta. Ashok Gupta, sir.
Thank you, Mr. K. Gupta. Thank you, research and thank you, my panel colleagues and IP and bankers. And this platform is giving me this opportunity where I can address the issue pertaining to challenges and streamlining the liquidation process, as well as what are the key challenges in the process. So, because everyone aware about that, IBC is revolutionary. And we want to create an efficient and effective management or effective system to get the CIP process or liquidation process in the timeline. Because IBC have the one object, time is the sense to achieve the maximum value. Now, what kind of challenges and how can be streamlined? I just address those issues by sharing my one PPT. Sir, is it visible?
Visible, sir. Visible. Please go ahead.
Now, first challenge is delaying obtaining or getting liquidation order from the NCLT. That is first challenge. Number of cases are pending for the liquidation. So when COC is only concerned about the CRP cost, and CRP cost is going day by day on account of delay in getting the liquidation order. This is the first hurdle. How to stimulate? The NCLT avoid the frivolous application and speed up the liquidation order so that liquidation process can be faster. Second is delay in disposal of the pending cases, including perfect transaction, 19(2), non-cooperation, PMLA enforcement, objection by the promoters or ex-management. This is second hurdles. Third is sometimes RP refused to continue as a liquidator because now when he understands it, there is no assets in the company. It means no fees, and no fees, he is not interested. Then problem faced by the liquidator who is going to appoint by the NCLT from the panelist. And what will happen, you understand that. He do not have the assets, he do not have any party to contribute in the liquidation process, and then all the hurdles started from that first point. Now, second, the challenges in the process. That is first thing, if COC confirmed to get compromise arrangement under section 230, you have first 60 days timeline. To sell the company as a going concern, 90 days timeline. Whether you start the process by giving the advertisement for 230 section or going sale or simultaneously. When you complete the publication time is 30 days for filing the claim. Then 30 days for the getting the list prepared for the list of stakeholders, preliminary report filing, all this thing. By that time, you should complete the section 230 requirement. If you receive any scheme under section 230, which shall be rejected thereafter, then you will miss the bus for sale the company as a going concern because timeline is 90 days. This is again a hurdle. Now, third thing is that what happens if some proposal is there for OTS from the ex-management or any stakeholder, and then withdrawal process are there. This will again delay the process. Then fourth thing is, if you are not able to assign the assets under section or regulation 37A in assignment of not redeemable, realizable assets, then what will happen? Because till you are not disposing the assets of the company, you cannot file the application for dissolution under section 54. Then next. Now see the challenges from the stakeholder consultation committee. Now dispute between the ideology or view or idea of the stakeholder consultation committee or decision taken by the liquidator. They may be clash. Second, who will AR of the if number of operation creators are there, if farmers are there, workers are there, if there are number of government dues, who will lead them under stakeholder consultation committee? This is also a question. And major challenge is deviation in the decisions and how to put up the justification. This is again challenge for the liquidator. These are reasons which delay the process. Now next, the complexity in the relinquishment of the security interest in favor of the liquidation state. What happens if suppose some of the stakeholders give in favor of the liquidation state to security or because the relinquishment, and some of the stakeholders deny or refuse, or sometimes they delete the column. That row is deleted from the form itself. हमने तो भरा ही नहीं, you can't decide yourself. That is a challenge. And what will happen if 50% or 60% or 66% will relinquish or not relinquish? Then whether you will follow the SARFAESI rule or what? Then issue is the bank level. Sometimes bank is not hand over the property document, or sometimes contingency after the disposal of the assets, or sometimes bank is not relinquished even after 30 days. And then after 6 months or 1 year, so many cases we have seen, after 9 months, bank is not able to sell the assets under section 52, and you are holding the liquidation process because we are waiting for disposal. Then question about how to deal with the PF department, how to deal with the excise, electricity board, who have first right on the assets of the company. Then challenge under the sale process, challenges created by the government department. Now we are also creating problem. We are always putting the word age and wage basis. Can you sell the going concern company the age and wage basis? It means you are selling the asset with the liability. And when you are selling the asset with the liability, tell me, if you are the investor, will you buy the property with the liability? And then constitutional challenge is there for selling the assets. If suppose you are having company and have the assets in Kolkata and Delhi, Delhi is only land, Kolkata is a factory. Or we can say automobile company is there, having the long-term contract with the OEM there. Can you sell the company as a going concern without selling the liability? That should be part of the, and why the party or financial creator or the charge holder who have the land in Delhi will bear the liability of Kolkata. Then constitution challenge under section 14 of the Constitution Act. the violation. So equality is the violation there. There's a different order there. We are waiting for the sometime or this thing ideology or jurisprudence from the peak perspective or liquidity perspective, then bench perspective, then enclave perspective, then Supreme Court perspective, then one decision fail and another decision. These are the process taking. Now issue about the reserve price. SEC says you start from the higher. IBBS says you start from the realizable value as declared by the valuer as a reserve price. Then market strategy is something different. How to achieve maximum value under the e-auction process. Title deeds copies are not provided by the bank, and there is mismatch in the title deed and actual information shared by the bank. That will also create a problem. Then removal of the plant and machine from the factory land. Sometimes vendor asks, sorry, this purchaser asks, I need at least 6 months time to remove this property or plant and machinery from the factory. Fail of the e-auction, then forfeit of the money, then filing the application the successful bidder for refunding the EMD, then NCLT will allow the refund of the EMD. This will again create problem. Then this will also impact on the liquidation fees because the time what is spent in the litigation over time in the failure of the e-auction will cut your commission or fees under regulation 4B. Then sale under private sale is again problem. You file application for allowing the private sale and some other party comes and offer better amount, then again issue. Then delay in providing copy of the original title is okay. Moratorium as per new order of the Prerna Singh and Salta Food, Enclave says the moratorium will be applicable only for the new on the new proceedings. But what the proceeding stop under CRP will start here. This is again a challenge. Then record keeping, preservation of books and data is again a question mark. Because if case is there, if any proceedings are open there, if any PMLA activities is going on, you have to keep the record of 8 years prior to opening of that case. That is one thing. The second thing, keeping this record, then keeping data in the cloud or some electronic mode. But when you need original document to face any challenge, that means you need to preserve original books of record also. So this is again a challenge with linking on the time frame. Anyway, then cross-border transactions, like Gupta ji said, we have to come up under insolvency or ranking, improvement of the ranking of India. That means we should deal in an effective manner in a unilateral transaction, that is cross-border. Now, then the issue is about disposal of the assets. If expenses are over value of the assets, what we realize in the foreign market, what kind of cost of the litigation is higher there. Sale of going concern, settlement of dues in the abroad. Then disinvestment. What are the requirements? What are the norms? What are the terms and conditions of the repatriation of the money into India? And what are the RBI norms? How to deal with those things? And under assessment, like in India, PMLA or ED, same thing may be applicable in abroad. How to deal with those things? So collectively, we can say we have to cover these all problems, challenges in some effective systems and try to minimize the litigation as possible. And smartly, you have to run the process and dispose the assets as possible as faster mode and take SEC into confidence by moving everything. Might be things are there, but try to avoid the litigation and do the process fast. This is only the possible options available to get stimulate the liquidation. Otherwise, you will get delay. But yes, you do not have any right or power on the NCLT because NCLT take their own time. But you should try to finish the task within time frame given under IBC. That is only options.
Thank you, Gupta sir. I think you have covered very nicely. One or two point one I feeling it. You also mentioning when there is no assets, sort of still then dissolution has to be filed. Dissolution should be there, and it is unnecessary a cost factor for that. Have any solution for that, Gupta?
Yes, sir. There are two, three cases which we have found that there is no assets in the company. And it was very good for the RP who informed the NCLT about there is no assets in the company and they allowed to dissolve the company within CRP.
It can be done that way. It can be done. What you are
One
talking
thing.
about,
Because you have to
it can be done.
justify, you have to convince.
Natural. जो IP है, he should convince the NCLT that if they are satisfied, it can be condoned for that. I think this is one issue. Another point, Gupta ji, we were talking about, party are removing sometime plant and machinery and also selling the land and building also. Because before liquidation, they are well aware that the company is going for the liquidation sometime. So have any time frame is there before that they'll send to their own relation or something like that, whether that sale can be null and void. Have any view on that?
Sir, what is sale, sir? Now we have to understand the commercial angle.
Yes.
Sale transaction means when you deliver the goods to the party. My advocate learner friends are here. Sale is complete when delivery is there.
We will just talk to him also just now. Please, this is a most important aspect.
And what is delivery, sir? Now this thing, in one case, what happened? They took even the grills of the building, shades of the building. They consider all the iron parts as a plant machinery part. Right, sir? So this need to be very distinguished. You have to keep very clarity in what assets are exactly in the plant and machinery.
No, my point only.
Sir, I'm coming to a point, sir.
Yes, sir.
I'm coming. Now, sale null and void. If sale under before CRP, that means you have to file avoidance transaction only. In case you justify that or you convince that the transaction attacked under section 43 to 50 and 66, then you need to file the avoidance transaction only.
So point, Gupta ji, the sale can be void for that. If he is selling to some relations and he is selling for other considerations. So
Yes.
if you are justified that sale can be null and void. I think the period also specified 1 year and 2 years also. Within that period, if some sale was happened, that can be null. I request Sri Advocate Sir, Stindra Sir, have any views sir on that? आप unmute कर लीजिए Stindra ji, please.
Yes, sir. Actually, if any transaction has been placed to defraud the creditor, and to defraud the creditor, then we have unlimited time period. We do not have any time limit of 1 year or 2 years. We can go into any extent.
No, but I'm seeing somewhere they mentioned if the relation is there, then
yeah, 2 years.
2 years. If it is some other transaction, it should be 1 year.
1 year.
Think, something like that, which I am reading.
Yeah, it is exactly written in the code. But in case of any transaction has been placed to defraud the creditor.
Yes, sir.
So we can go
that
beyond
is a fraud. That is a fraud.
In case of
considered as a fraud, then problem is different.
Yes.
If it is not a fraud, then point is something different. If
in one of my case, the suspended director has been transferred the land by way of gift deed to her wife. Okay. The agriculture land, that was the agriculture land that was belongs to the corporate debtor. And by virtue of a gift deed, he just transferred the agriculture land, part of agriculture land to his wife. By simply mentioning that I am so-and-so person, I am managing director of this company, and due to affection, natural affection and love, I am transferring this part of the asset to my wife. And after 1 month, he again executed a corrigendum deed and mentioned that in that deed and in that gift, the donor name was wrongly mentioned as Mr. X, managing director of YZ Limited. And correct position is The name of company is YZ Limited through its managing director. So by virtue of these two deeds, they have taken the asset in the hands of the corporate debtor to his personal benefit. I have filed an avoidance agreement, avoidance transaction under Section 43 before the Honorable NCLT. So Honorable NCLT asked me how it is happened, how it is possible. So I have submitted all the document along with the certified copy of the title deed and other things, and they have issued notices to the corporate other side. And when they appear, they realize and they gone into the compromise. The matter is settled within just 3 months.
Very nicely, sir. I think I have also experienced when I'm in a bank. Some people are playing such a frauds. And they
Yeah.
are transferring to their relations, they are transferring to third party without
Hmm.
any consideration for that, just like a gift or something like that.
And in this case, sir, we cannot find from the balance sheet because the
Cannot find anything.
consideration is nil.
Well, yes. You cannot find
The
the balance sheet. You have to
yeah.
stay past. Yes, sir. Gupta, sir.
Sir, there is a one issue under word relation. Because we are binding to file any application if you parties concerned and connected covered under section 524
Sir.
as a related party. If it is beyond, maybe in your relationship or other way, parent or whatever, then you do not have any local standing. But one word is there, the very important,
Sir.
whether the sale was happened under ordinary business.
Course
Course
of
of
business.
business. Course of business. You are right. Very nicely, Gupta. Yeah. Sir, Arvind, sir, have any views, sir, of that subject, sir? Because this is the most important issue these days. So, have any view? Unmute किए रहेंगे, sir, Arvind, sir. Mr. Arvind,
Yes.
have any views, sir, on that aspect? What we are talking about?
Sir, I agree with the things on this that it happens in the avoidance, the documentation which is done is basically unearthed during the liquidation, and that avoidance thing is actually during liquidation creates a problem because to complete the liquidation, this keeps on open end.
Okay.
And what Gupta ji also in his challenges raised about non-realizable asset, which is there. So this becomes a part of that, and that itself is a topic where a lot of litigations down the line I foresee to come, because fixing the reserve price on these things to sell under a NRA sale will be always a challenging thing.
Gupta, Mr. Arvind, just I am asking you whether, as we are discussing, Mr. Ashok Gupta, that it is difficult for the liquidator to sell the corporate debtor as a going concern. What are you talking about? As a going concern, there are so many ways, there are so many issues, whether you're talking about the labor, you're talking about the government due, you're talking about other things. Have any views for that?
Yeah. Yes, Gupta ji. So basically, when you talk this concept of liquidation as a going concern, now this came out, this concept when the law was enacted was not there. This has come out after NRE Coke judgment, where they wanted to continue the company and the employees and all. It was a going concern, and because of that, this amendment came. And regulation 32A was added thereafter. So if you go through the whole process of timelines, now first of all, we need to understand the liquidation sale as a going concern. So under regulation 32, this has been added as a subclause E, that the corporate as a going concern, and then 32 regulation 32A came down where the application is being filed. The COC decides on this sale as a going concern in the application itself of the liquidation, where the liquidator is the RP is filing, and they come out that which are the assets and liabilities. So 32A2 gives the clarity on this, that the assets and liabilities of the corporate debtors are identified by COC and given in the application itself. And in case it is not there, then the liquidator will finalize this. Now, this all things what he has to do in case COC has not identified, and if the liquidator has to do it through a SCC committee, then the challenge comes is the timelines. The timelines in 90 days to do this. So there was also a concept of Section 230 under Companies Act where the compromise comes into play, which was also raised by Guptaji in his first slide, which has to be done in 60 days. Now, this all has to be seen together. We have to consider if the scheme is coming, then scheme requires the approval of 75% of the all the creditors. So where CRP has failed with having a 66% approval of the financial creditor only, basically COC mostly comprises of financial, getting scheme will be always is challenging. So that's then that it opens up Pandora for sale as a going concern. So you have another 30 days after the failure of that 60 days where scheme cannot be passed. You have a thing to go under the sale and as a going concern. So we are trying to actually, it is a the company, the CD, which is on ventilator, to be very fair, as a human being, when we go on ventilator, probability to revive and come back is always out of 100, 2%. So our companies which are there on ventilator, we are pushing them into liquidation. Then
Sir, your voice is not coming. Yes, sir. Yes, sir. Please, please. Carry on, sir.
Yes, sir. So giving them one chance through scheme, then another chance to sale as a going concern. But by doing this, how do you sell this as a going concern? There should be a value in the business to be available. That now there has been a recent judgment which has created again turmoil in this. In the case by the NCLEX, which came recently, where this going concern say, they have said that it is with liabilities. Now that Vishesh Services versus SV Ramani, which was that, which has come. Now that case, in my view, is a standalone case, should not be considered as a landmark judgment or a precedent for other cases. Because if you go through the facts of that case also, we will understand that the valuation, the reserve price that has been fixed in that case, which has come up, is the liquidator in that case told that it is including liability. And because of that, this has come up. So, and whereas in most of the sale as a going concern, it is the reserve prices of assets, because whatever is realized from that asset will be paid as per 53 to all the liabilities that has been collected by the liquidator. So, but because in that case, it was given valuation and reserve price was fixed with liability. So probably that was the judgment. Now the challenge that rises is in this 90 days period to conclude the sale is a challenging. To this, there has been one more matter where another 90 days extension was given. So you have a precedent where this 90 days extension can be sought. So in that, there was a case where the liquidator sold the company in 90 days as a going concern. The buyer of the CD in going concern could not make the payment within the stipulated 60 days and requested for an extension of 120 days. And the RP forfeit, the liquidator forfeited the EMD and the money that had been paid. And the matter was taken to the adjudicating authority, where it was described that if the bid document does not have such clause of extension, the extension cannot be granted and 90 days becomes the limit. But as there was already an attempt made by the liquidator and the company was sold under the going concern by him, but the party who took it has defaulted, in view of which one more attempt to sell again under the going concern sale, another 90 days be given and the liquidator to proceed with another bid document was given. So the challenges are there, and that challenges through a judicial pronouncement and the support of the adjudicating authority can be extended and can be seen, in my view.
Very nice. Please, Gupta sir. बताइए sir.
Sir, there are three major concerns about sale as a going concern.
Sir.
One is when liquidator issues a notice, sale notice for e-auction bidding process, he only requested to deposit 5%, 10% EMD and name of the companies to sell as a going concern, what he offers.
Okay.
And bidders deposit 10%, 5% EMD. There is no question on the relief and waiver.
There's no question of what?
Relief and waiver, concessions,
Okay.
that is one.
Okay.
So sale as a going concern is not a resolution plan. In earlier orders, the NCLT considered this is a last resort and a preamble of the IBC to revive the company, so allowed the sale as a going concern. And sometimes they also, with the same idea, jurisprudence, ideology, allow relief concession also, which is not asking by the bidder, the challenge from the other side. Then put the clause age in various basis. And you are saying age in various basis. So with the question about you are not taking the liability, you are not assuming the liabilities. And the third thing, what is peculiar liabilities? Liability directly related to keep the company as a going concern. Otherwise, company nil. Like any long-term contract of the AEM. If you cancel that contract, the company cannot run on going concern. Going concern is only become a tool under liquidation, which motivate people to not to participate under the CRP, but here, and we are losing the money into CRP. Yes. And
Like,
what
what you are talking about, I understand. Like, what are the solutions for that? There must be.
That's why liquidator must maintain proper process document.
Yes, yes, yes. That is a
This is
point.
the solution. If
And
we see
also, yeah, this is offer and counter offer, because these both advocate are very innovative in their
if
choice.
we see the
Their
judgment
role
pass
is
in
very
the
important, because they should keep the clause slightly. They should be offer and counter offer. Then bidders say, I need this kind of relief and concession. This should be clearly decided prior to submission of the EMD, so that this same application can be put up before the NCLT, and Honorable NCLT will not have any issue.
So that means for ongoing concern, what we are talking about the liability, it is not seized when it is a liquidation has gone, and the liability will be set off by sale of the assets only, as per their percentage. It is not
No,
like
sir.
that.
No, sir. One more point here.
Yes.
What is Section 32A? Section 32A
going concern.
give the right to the creditors to recover the money.
From whom?
The misconduct or miss thing
That is
happened.
personal liability. That is personal.
No personal liability, sir.
Oh.
If anything happened prior to CRP period,
yes,
pertain to those transactions, 32A allow creditors.
Yes.
That right will defeat if a sale is a going concern, because when the liability is taken over a sale is going concern, then you do not have any right against them under Section 32A.
That's what I'm
My
talking about.
understanding.
They have no right against that.
Can explain better, I think.
The point
Actually,
let me very clarify the point. When a going concern is there, the liability of the creditor are still coexist.
It will depend on the drafting of sale documents, sir.
Yeah.
Actually, it was held in Shri Shakti Interglobal Export Private Limited versus KTC Foods case by Honorable NCLT, that once you have drafted the condition in your auction document that the property of the company will be sold on going concern basis without any liability. Only we have to, only the bidder have to put the value for the asset.
Part of your sale agreement.
Exactly. It should be mentioned in the sale agreement that property will not be sold on as is varies basis. The property is sold only without any liability, and the asset amount, recover amount, will be distributed in the compliance of Section 53 of the IBC. If it is mentioned in your sale document, then no problem will be.
Gupta, you agree with this? Gupta sir, you agree with this? What our learned advocates are telling, is it okay now? Hello, Mr. Kandar sir. I'm sorry I
Yes.
have spelled out your wrong name. I was not
No,
knowing
sir.
that Arvind is your father.
Sir,
I'm like,
sir, you spelled my father's name, so I have no issues.
actually, in our name, KK Gupta, Krishna Kumar Gupta, middle name is mine. So it is your Snehal Arvind Kamdar. So I
Yes.
feel that your name is Arvind also.
Arvind is my father's name, so
I'm extremely sorry.
took pride by not
I'm
objected.
extremely sorry, sir. Hey, you tell me one point, sir, for liquidator. Once liquidator is appointed, it is mostly IP. So there's no money. So to whom he can have expenses they should meet. Have any view, sir?
Sir, if you go through the whole process, like when the liquidator is appointed, first of all, we need to go one step back. When the liquidation application is filed, when the name is suggested of the liquidator, the consent is taken by the of the liquidator while filing the liquidation application. Vis-a-vis, the COC is also bound to give a liquidation plan along with it when the liquidation application is filed. The major issue that we find is this: both the things are many times missing in the liquidation application, and thereafter the problem arises about how the funds will be which is required to run the liquidation process will be looked into. So as a liquidator, when you are giving a consent, you need to know that on that part. And secondly, the liquidation plan gives you a good insight that how that cash flow will be done. So that the COC member who takes the company into liquidation, in their liquidation part, they will have to bring in the cash flow which is required to run the liquidation process. And that should be a part of his liquidation plan. And that is where the liquidator will be able to run the show and bring the finances or required money to run the liquidation process. Sir.
That means the creditors, committee of creditors,
Yes, sir.
there are such expenses. What are you feeling if not planned?
Yes, sir. So when the liquidation is planned by the COC, it has to be funded by them. Otherwise, in case there is no asset and the company needs to be taken into liquidation, the liquidator, apart from liquidator fee, the other cost that he has to bear to dissolve the company will be a challenging thing that comes up. So here, when you talk of liquidation, again, one point about the going concern which we're talking, I will just link it to that also. In liquidation, after liquidation, dissolution takes place. Okay, but when it is a going concern sale, there is no dissolution. The company continues.
Okay.
So that is based on the another Supreme Court judgment where of Arun Jagratka, where it was said that the clean slate can be extended for the revival of the company. So if there is a probability of revival, then this clean slate should be given, and then it can be given into the things. What is happening in the regular course is the defining this going concern either in the application by the of the liquidation or by the liquidator when it is a going concern which he is trying to sell. If the revival is not possible, then it has to be, in my view, brought to the light of the adjudicating authority with a proper reasoning. Yes, sir.
One more thing, the liquidation plan should be.
Kamdar sir, just I want to know one point. If
Yes.
it's going concern, I take on of that company. Okay. Now who will give a certificate that they should come as a clean slate? And all the levity of the creditor has gone. Whatever settlement has been made by the IP, that will only be there. Otherwise, it will be nil. Now, my question is very, very simple. If I have taken over all the assets and liability, I will say it is tended to be zero liability as on the date of takeover because I have paid some amount through the NCTL to the company, to the liquidator, you can say, or to the IP. So my slate is very clean, no? What do you feel?
Sir, I repeat. Now, when I go as a sale as a going concern,
yes,
let us go back to our regulation 32A. Okay. So 32A1, it speaks that where the committee of creditor has recommended sale under clause E and F of the regulation 32, that is going concern sale of a corporate debtor or a business going concern sale. the liquidator is of the opinion that the sale under clause E or F under regulation 32 shall maximize the value of the corporate data. He shall endure first sale under the said clause. And clause 2 says that for the purpose of the sale under sub-regulation 1, the group of asset and liabilities. So it talks that it is not the complete company assets and liability. It speaks about the group of assets and liabilities of the corporate debtor as identified by COC. And in the subclause 3 says that as identified by liquidator, that goes with the company. It doesn't take all the liability. So the question that was raised initially by Gupta sir, that about the caveats and prayers basically comes into play here. What are the assets and liability that are put for sale with respect to the company? So you take a company and you take a part of the assets and part of the liability which is required to continue the business or continue that company as a going concern. This can be elaborated that if there is a pharma company, with pharma company, the factory license is attached with the assets. It is not with the company. Similarly, there are certain licenses which goes with the company, not with the assets. So where the licenses are with the company, not with the assets, in that case, if anyone is buying the asset, but that license is not available with him, he will never be able to run the show of the assets. So in view of which, this clause 32A, clause 2 and 3 needs to be read where the identification of asset and liability is done either by COC member or by a liquidator where COC is not identified, which is put to sale under the going concern will be the part of it. So whatever is realized from that will be collected by the liquidator and pay off our other liabilities.
Right.
Else, what will happen in case, as you said, if it is made zero, then what will happen is that in case this can happen a situation where net worth of the company is high, where net worth is eroded, this zero balance sheet will have no issue. But if there is a net worth, then what will happen? The liquidator will get money where assets are more and liabilities are less. And that money, he will have to pay that to whom there is no liability, then it will go to shareholders. So then that will actually breach section 53 because other liabilities, other creditor of 53 stakeholders who come under 53 will be paid later and the equity owner will be paid first in that scenario. So it has to be understood in toto that it is group of assets and liability identified by COC or liquidator that is put through sale undergoing concern, and balance liability will be paid out of the funds which is received from this sale.
But sir, in a liquidation, any firm is if under liquidation, what you are talking about is net worth. Net worth definitely will be negative now. I think it cannot be positive. You feel
No,
that
sir.
positive is there?
Yes, sir. Sir, I can share like what is the IBC is basically based on the default. So there are many solvent companies which get defaulted and they get into the challenging position, and in CRP they fail. But there may be a illiquid asset or a asset which may get liquidated over a period, may not be having a cash flow at that time to pay off the liabilities. But when it comes to liquidation, there may be assets like one of the case what our advocate brother just said, where they came down for a compromise when the avoidance agreement was shown, and that land came back to the company, was to come back. And why did they went for compromise? Because as soon as that asset is coming back to the company, the positive company's net worth will come positive. So in that scenario, to avoid that situation, basically we need to see in this when 32A comes, we need to see that net worth comes into play and it will play a big role there.
Very nice, very nice. And I think it is addition to my knowledge because the resolution plan has not been accepted. Still, they are coming for a compromise and getting the assets back into their. I think this is a very, very interesting. Gupta, you want to say something? Yes.
Yes, sir. Now, here two challenges can be removed in such manner. When COC will not decided in under section regulation 39 about total cost of the liquidation. Second, if any liquid assets are there. Third, how much contribution is required to be put by the COC member into liquidation account, escrow account for running the liquidation process. In that case, in one case, we request NCLT and NCLT directed COC to first to resolve this mandate. Then we will move the application for the NCL liquidation. This is one option.
Very nice.
Second, if you are appointed by the panel, under panel, so you don't know what happened in the past.
Very interesting.
That is-
Very interesting. Very interesting.
That is the
Really-
request IBBI.
Very interesting. Kamdar are very interesting what you are talking about. I think
Yes.
we require a sufficient time to discuss all such things
Yes.
with you. I think this is a very important subject on this, because I feel that myself also expert under the system. Still I am getting something additionally, because you have practical knowledge for that. So, sir, I will come back to you. I am coming to Shri Sitendra, sir, who is an advocate, and he is the right person to talk about so many things. Sir, that means what we are talking about, sir.
Yeah.
So there is some delay in sale, one region or the other regions. Have any views, sir, for that? Because you are the expert in that field. Because you are the person who is suggesting the people how you can have a delay, how you can take a date, how you can
No,
play the
sir.
protest.
I am on the solution part always.
I'm
Although I am.
I'm talking about if you are in another desk. If I'm a banker, I'm also telling. Now I'm at a different desk of research in India. Now I'm telling how to get a loan from the bank. So because the question is a change of the seat. Now, so what are you feeling, sir? Actually, if I want your practical insight for the participants, sir. Please.
Actually, there are three ways to see any situation. It may be a problem, it may be a challenge, and it may be an opportunity. It depends on us how we react the situation. So, as far as the liquidation is concerned, and as far as the sale of asset is concerned, it is a very, very professional work. We have to plan each and everything from the beginning. I want to say, from the last COC meeting, we have to draft the way, because our CARP has been does not succeed due to certain reasons. Now we have to go on into liquidation. So at the last meeting of COC, we have to get many resolution for the liquidation, like the liquidation cost, like the going concern, like the mode of sale, etc. And so the planning is start from the last COC meeting, and after that, when we get the order of this liquidation, on that day we have to also put the planning to sell the property. Initially, we have to decide from which way we have to put the show on next level. Whether we want to go for this going concern basis. If we are trying to sell the property on going concern basis, we have to draft each and every clause of our sales notice very carefully, including what kind of assets are available for in going concern, which are the separate assets which will not be part of that, as our learned friend Snehal sir has already told. And after that, we have to also put each and every clause very carefully regarding the contingent liabilities. If in any case, this we are going to sell the property on going concern basis, it may be possible any contingent liability will arise on that asset. It may be also possible that some property is also attached by any other government department. When we sell the property on going concern basis, if we put the clause as is various basis, as Mr. Gupta has already told, then that attachment will also prevail. Even if we have sold the property on going concern basis. So we have to take care each and every aspect while drafting our sales notice and terms and condition of the sale. So it is very important to keep into mind each and every situation. When we plan accordingly, so there is no way then our purpose will defeat. And it is a planning is more important in all kind of these issues. We have to imagine what kind of problem may occur, what kind of litigation may occur, and we have to put each and every aspect in our terms and condition of option. So it will depend on the asset of corporate debtor. It will depend on the business of corporate debtor. It will also depend what kind of liabilities we have we have some labor liabilities, we have government liabilities, we have some attachment order, we have some PMLA attachment also. So we have to take care each and every aspect and decide our strategy accordingly.
Very nice. Right. Hi, Gupta sir, please.
So with addition to Satyendra ji, I just two small story. Within 2 minutes we can close it. One is the SEC members got a call from one of the investor. We want to buy this IP, intellectual property. That is, as a Chinese company, Chinese restaurant chain is there, and they offer some around 2.5 crore rupees. Whereas the actual valuation is fair value is about 1 crore, and liquidation value is 16,000. The cost we are paying to the registration of the IP. Now, and this offer was just offer, not in the any EMD or sort of concrete, and it was in 2019. Then Corona happened. The company is Chinese. No one want to buy this company or logo. Now, problem with the liquidator, he has to conduct at least 8 e-auction from reaching from 2.5 crore to 1 crore.
Oh.
Now, on valuation part, what is realizable value? The realizable value is even the less than the fair value.
Okay.
Then it means 2 years here and 1 year. And he is also always facing a problem from the SEC. This is one story. I don't want to say anything. Secondly, the promoters asking NCLT ki, when I took the loan, my property was 100 crore rupees. It's come down, and valuers try 6 e-auction and not able to sell the property in the 6 e-auction. Then he approached to the NCLT ex-management, and NCLT said, okay, he direct the liquidator to go for fresh valuation. Now valuation will be challenged by the ex-management, or maybe NCLT already stay the process, and it is already taken 6 month time. We don't know.
Gupta ji, Ashok Gupta ji.
Yes, sir.
To your point, after 6 auction, why do liquidator go to NCLT for fresh valuation? I think he should get a buyer and go to the branch that this could be allowed to be sold under private equity or under Swiss auction at this value.
He didn't go, sir. He didn't go. Ex-management went to NCLT.
Okay.
But actually,
by keeping him SEC member, he will create a lot of resistance problem to you.
Okay.
Practical experience is like that, because I'm just telling you, as a banker, once party is taking a loan, that valuation is something different. When account become a stress asset, or you can say NP level, so valuation is entirely different. So value is from the bank only. I'm asking the valuer, you are the same valuer. Once you are giving a loan, so your value about this much. Now again the inflation price or other thing has gone up. Now you are telling this is value. I think this is system defective, sir. That is what I feel. I have any opinion? You tell me, sir.
In one of my case, I got the valuation report from the banker, and he was insisting the valuation should not be less than this. So I said no, I will take my own valuation and do it accordingly. I have also taken the copy of invoices that was submitted by the borrower at the time of finance. So I have just called the supplier. I want this type of plant and machinery for my plant. So how will you quote? तो उसने पूछा कि सर क्या करोगे आप इसका, आपको बैंक में देनी है या नहीं देनी? फिर मैंने उसको ये कहा, I frankly speaking कि I am just asking to purchase this property. मैंने उसको नाम बताया कि this was the property I want to purchase into auction. So at the time of finance, you have submitted the banker is telling it is around 2 CR. So he told me कि सर आपको ये चाहिए तो आप नया ही लो ना, मैं आपको नया दे दूंगा 75 lakhs में, तो इंस्टॉल करके चल जाऊंगा along with the 3 years guarantee. So this is the position, and banker are insisting कि भाई उससे कम rate नहीं आनी चाहिए. So it is very much challenge. So in that case, we take the fresh valuation quoting all the elements on record regarding the substitute plant and machinery available in the market, taking quotation from other suppliers also. So we have to put each and every paper on record regarding why we have.
It is a practical thing, sir.
Yes, sir, it is a practical
I'm
thing.
just telling you, when I was GM Delhi also, one case came to me where he had given me quotation of this much. Then I telephoned that purchaser, what you're talking about. Then value was entirely different. You're telling I give you on such amount. When you're taking a loan from the bank, so all margin also included in that. No? And that is a part of the game. Sir, another point, Sitendra sir, Rajesh, I'm asking you, as a secured financial creditors, if I will not allow or relinquish my charge, so what is the status for the sale for that?
For the sale of assets, asset will be sold by the secured creditor in that case.
The secured creditor is not giving reliance to the liquidator. Okay, I will not give.
Yes.
In that case, as a liquidator or how?
Actually, sir, what I do at that last COC meeting, I put each and every situation before the COC. If you relinquish the security into the liquidation state, then I will charge this amount. If you don't relinquish, you will take back. I will charge per month fees. So it should be drafted.
I'm asking a solution for that. And what is solution in that aspect?
The solution is also that at the time of last COC meeting, we have to take the mandate in that case also.
Okay.
Sir, can I add something?
Please.
Sir, when you are talking of relinquishment of rights, security rights by the security charge holder, so what happens is in first 30 days, they are supposed to either relinquish or take the asset out of liquidation estate. Okay. Now, let's understand the point that when they take out of liquidation estate, they have to see that it gets sold in 90 days.
That is
because after 90 days, if it is not sold, it comes back to the liquidator. That is what the loss is now. Now the challenge is that can be sold in 90 days only and only if before the start of CRP, they already have gone to DRT and the decree is already with them and they only require to execute that decree.
Okay.
Then only that 90 days sale can happen. Otherwise, if they have to go under SURFACE, because if they have to sell, then it has to be sold under SURFACE. So under SURFACE, it cannot be sold in 90 days because that process itself is 120 days. Secondly, there is one case pending decision on this. So after 90 days, it comes back to the liquidator. Still, the right holder has not relinquished the right. So what it means? It means that the liquidator has to sell all the asset, but that asset doesn't become a part of liquidation estate. He has to sell for that person, the right holder. And from that, whatever is to be recovered, he can recover towards the liquidation cost and balance he has to pay back to them. So this is the understanding of mine on this point. Yes, what our advocate brother has said, I 100% accept that we have to be vigilant as a liquidator because last COC meeting is very crucial. And if you have not taken all this into consideration and COC is taking all this very casually. So if we don't take this in the right spirit, in liquidation, it becomes a very challenging group. One more point, sir, on liquidation, which in challenges which Mr. Gupta had raised, which I would like to share is that in going concern, when we are talking again, it is like CRP only. So when on the 75th day you come as a UI, you don't go preparing the teaser or you always start the process beforehand. So here in 90 days, when it is to be sold, as soon as you are becoming a liquidator as a going concern, you have to start marketing the liquidation company, which is going to be in going concern. So by 90 days, you are able to sell it. And one more point, which was on as is, where is basis, which was we discussed. On that also, I would like to throw one light that it is as it, where is basically with respect to the asset. It does not get clinched with the liability. This as is, where is came out into play in liquidation and everyone started writing in the notice. But it is basically on the surface, it was widely used on the option part. So when you under surface, this was to be used as it is basically giving you that the asset is sold. So to give a simple example, if there are asset of 1 crore and or liability of 1 crore and asset is of 50 lakhs which is being sold, and there are two charge holder. So once you sell, that first charge holder gets something and his liability is not satisfied, the second charge holder will still stay cling to the asset if it is assumed that this liability goes with him. So that is a wrong interpretation which many times people understand. It is with asset as it is, that means the condition of the asset. So if it is in a broken condition or a knocked down asset, then it is as you see that you are getting. But it does not mean that with asset the liability gets clinched. It only gets clinched when in your bid document you mention that clearly that with this asset this liability is given to you. Otherwise, no liability comes in liquidation on as it were sale basis is of my view.
Very nice. Gupta sir. Gupta sir, what you want to say?
Slightly different opinion of mine.
Yes, sir.
When Sarfasi, you mentioned age in very basis about the assets.
You're right.
But when
Yes,
you're
yes.
selling the going concern, means the company is able to bear its liability. That is the going concern international definition. It means when I am proposing to sell the company is a going concern, that means age in very basis means inclusive of the concern liabilities. Now, there are two ideologies. One say Section 238 oversees all the act and regulation or whatever. That is power under IBC, Section 238. Second thing, you are settling the dues of the claimant in terms of Section 53. So that is the only protection you may use in the court. But entry is very clear to what you are. So means we are professional, we should make what Satyendraji said, the proper documentation, clear crystal, what should be there. Now, second thing about the liquidation.
One minute, Guptaji. Guptaji, 1 minute. On this point, I would like to clarify that NCLAT in the matter of this Visist Services Limited, which came, they clearly said that what you are saying is what has been said, but when you read the whole facts of the case, the reserve price which was fixed with liabilities. Whereas normally when you see all the bid documents, it is send liability. So because that was a case where the reserve price was fixed with liability, so in that case, it is considered it goes with liability, and Section 53 may not have a clash on it. But in almost all other cases, if you go, it is without liability, and Section 53 distribution will prevail.
Very correct, sir. But only one more thing here. That is the base of the judgment was constitutional challenge of the equality, violation of the equality. So that's why I define if the assets in Calcutta or Delhi or some, what kind of asset, what is the going concern, that need to be defined. Anyway, we should be clear what we are doing. First thing. Second thing, if relinquishment is not given by some of the bankers,
Yes.
so FC, then if you have the mandate of more than 60%, you sell the property and don't worry. Because under surpass it is very clear. When 60% over the decisions are there, you may sell and distribute the property as per there. Because this is there some judgment also on this issue. Third thing, when relinquishment issue is there with some one or two or exclusive banker, then whenever you get some offer to buy the property, you may reach to the banker, that secured creditor. Yeah, I have offered for so much money. Within some certain days, 21 days, I think they are. If you're able to say me you have buyer over this amount, then okay. Otherwise, and for that you may.
Consent of the bank is required in that respect. What are you talking about?
Yes.
Sir, Satendra sir, there is
Yes,
one
sir.
question, sir. Just I am asking you if you can give a reply for that. This is Madan Lal Agarwal.
Okay.
Just you see from your screen, in a corporate debtor undergoing liquidation, proceeding, steel structure weighing 50,000 metric ton was sold in the last quarter of the specified liquidation period. But the steel could not be removed within the specified period. Removal took place about 10 months. They went beyond liquidation period of 24 months. This is a practical situation. Will NCLT consider extending liquidation period in such cases?
Actually, this question is required further explanation whether the land and building is part of liquidation state or not. Whether they have put any condition that in how much time the successful bidder has to remove the goods from the located asset.
Okay.
So I think
If such condition is not there, Srinder sir,
yes,
so whether such condition is not there in the sale agreement, so whether
yes.
the period can be extended.
Actually, we have delivered the if land is not belong to corporate debtor, there is no issue. We can file application because we have received entire amount. There, the time limit is vesting in the removal of the goods from the asset. If the asset, the land and building is not belong to corporate debtor, why it is required to file an application for extension? Because we have put the delivery, we have handed over the delivery and possession of the goods once we have received the payment. It is not our cup of tea in how much time we remove the goods from the land and building.
Very, very important. Sir, really, advocate brain is there.
Thank you, sir.
But sir, two things are here. If land is subject to sale, one thing.
Yes.
If land is subject to sale, one thing.
Yes,
If land is on rented basis,
yes, sir.
then
So,
again
situation
you
is
come to
rented.
back. You have
Yes.
to make process document properly. You should remove the asset within so much time.
Actually, all the situation has been to be imagined at the time of drafting the terms and conditions of the.
That is
I
what-
always put in how much time he has to remove the goods from the. And I also point out one more thing. If plant and machinery, if land and building is also in the possession of corporate debtor, in the ownership of corporate debtor, the bidder who remove the plant and machinery from the building will not cause any loss to the building. If he incurred, then we will take compensation from that. In one of my case, there is need to break one big wall. So I have also put the condition that you have to reconstruct the wall once you have removed the plant and machinery from the premises.
Very nice. Kamdar sir, you want to say something?
Yes, sir. Yes, sir. On this point, when we are talking, basically on what our advocates are said, that the sale document, what we prepare, should envisage various things. Now, if you want to take a support of the adjudicating authority, what extension point was raised, you can refer to a ABG shipyard, where not only the extension was given for removal of the thing, but even extension was given for repayment of the things, and also the process where e-auction process is notified, a process to be sold under private treaty was given. So in liquidation, so that ABJ shipyard judgment can come handy in case there is a issue coming in the party who has bought to pick up the goods. In case the money which has to come in the 90 days, that is 30 plus 60, 30 days without interest and plus 60 days with interest, if they are defaulting, then before the period ends, they can take the support of ABG and come out with a direction from adjudicating authority to say that the sale gets concluded. Keeping it open creates again one round of sale, and that goes to getting lesser value, because as you move further, the value gets deteriorated.
In one of my case, the bidder has also taken the extension after 90 days. Because he has failed to pay entire amount.
That is possible. That is possible.
That is possible. Yes. That is possible. Not hard and fast.
Sir, another question, Srinder sir, whether you can reply it.
Yeah.
What happens if creditor has not relinquished the assets or not sold in 0 days? Then liquidator cannot file petition for dissolutions when there is no other assets or liquidation estate. Please clarify.
What happened if creditor has not relinquished the asset and
he cannot file a dissolution deed?
No.
If asset is there, how he can file the dissolution?
How he cannot file? He cannot file for that.
Sir, Guptaji,
yes, sir.
Guptaji, I answered this question probably because in past, as I told you about this process of relinquishment of right.
So,
After 90 days, it comes back to the liquidator only.
yes.
So
yes.
there is no question of that asset relinquished. Even if it is not done, the liquidator can sell off the things. And what Gupta ji told about 66% on the surface, I am not aware of that, but that is also there. So both the cases, asset will never remain after 90 days with the financial creditor. It will come with the security holder, basically. It will come to the liquidator, and liquidator will be able to sell it and dissolve the company later on.
The 90 days periods are there. If they cannot
Yes.
sell it, ultimately it
Actually,
comes
I
to
think as per my view, 90 days is only applicable when the asset has not been taken by the secured creditor. If he has clearly taken back, so there is no time limit, in my opinion. There is a judgment, I think, but there is no mention in any regulation that asset will come back after 90 days if secured creditor is not able to sold that property.
Thank you very much, sir. I think we have discussed practical aspect of all the thing, not going for a theoretical thing. And with our experience, we discuss. Lastly, sir, Sitendra sir, you want to say something to the listener who is our participant? Anything you want to convey something?
Yes,
Lastly,
sir.
let me one or two words, but you want to say something?
Yes, actually, the banker are looking for solution. I have experience since 2004 to deal with the banker. So
Sir.
they are asking for solution. People are saying they no one want to take the asset into liquidation. But as far as my experience is concerned, if we ensure the secure creditor regarding the valuation, because the ultimate object of IBC is to maximize the asset of the valuation of maximize the valuation of the asset of the corporate debtor. So if we put all our efforts with the smartness and the proper marketing skills, we can get anything from the corporate debtor, asset of the corporate debtor, more than the what they realize through SURFACE or DRT, and in much time. So this approach should be adopted by all of the learned friends, resolution professional liquidators, and also the bankers. So if we explore the opportunities held in the IVC, we find much valuation than the SURFACE and other DRT.
Very nice. Very nice. Sunil sir, you want to say something? Last word to the participants, sir? Your please unmute कीजिए, unmute कीजिए. Mute है सर ये आपका, unmute करो.
Sorry. So to all the participants on this liquidation, basically liquidation is the last stage. So as in human cycle, you have phases, and when you reach that last stage, you should understand that what are the capabilities that you have. Same way, when you take the company into liquidation, the expectation by the COC to recover the money what they had lended may not be fulfilled, because that was lended when the CD was at the childhood stage, and now it is in the last stage. So cannot expect that. And the valuation aspect, what has been discussed, valuation is the key for whole CRP or whether it is a liquidation. So a proper valuation will get a proper maximization of the value, and it may help in getting the dues to all the stakeholders accordingly.
Very nice. Sir Gupta sir, you want to say something?
Sir, only 2 points. Whenever they are facing any issue, we all professionals are here. They can discuss the issue ourselves, so we can conclude the best logical solution for the problem, and to complete the task as possible in the timeline, so that IB will not create any problem for you.
Thank you, Gupta sir, very much. I think this is a Resurgent India webinar of 138 we have already completed. Now, Resurgent India is a merchant banker. We are also investment banker. We are doing IVC also. We have professional IVC firm is also running, where we are dealing with the IVC cases also. And we are conducting technical economical viability study and doing valuation also for the assets and for the enterprise value. Resurgent India also sharing the knowledge among the participants. So in our web participant at present today is more than 500 session was there. I am not knowing how many attendance was there in, because it is YouTube also and Facebook also. Some people are attending for that program also. So, sir, we are also one association of the Financial Advisor of India, where we are having a 400 members. And we are also imparting a knowledge under the series. So we have already conducted 20 webinars under this series of different subjects. So mostly every week we are holding it. Like during last 1 month we could not hold it because of my illness. Now next Thursday we are also holding for the SME sector. So that was aspect of our main object of the research in India, to impart knowledge among the banker, among the participant. We are also conducting training for the bankers, and so many things we are doing it. I think this is today webinar. I am very happy. I also learned something uh, from the Kamdar sir and from Satinder sir, from Gupta sir. So many other information I got it. Really, Satinder sir, you are a brain for a advocate. What you are talking about, I must appreciate you. And Ashok Gupta ji, I think he is a opener batsman and a very all type of knowledge is there. He also associated with us in some other webinar also. We will try to call you. So at the end, because I overstretched the program by half an hour, because it is in all my webinar, it is also happened like this only. Because it is such an interesting subject we are talking about, and definitely people are appreciating us for that. Even I told you that while I was in a hospital, so people are telephoning me, even sending a message, how are you, Gupta ji? Really, this shows that it is a fraction of the participants in all our programs. They like our program. In the end, I am express my gratitude on behalf of myself and research in India to Shri Ashok Kumar Gupta sir, to Shri Snehal Kamdar sir, excuse me sir again, and Shri Shtender sir for excellent practical experience. We are not talking today anything theoretical. We are talking about from our heart. I express my gratitude for that, sir. Thank you very much, sir. With this, I am also thankful to my field staff who make all such arrangement. Even last moment, you told me, Gupta ji, you have to do the webinar. If you're feeling comfortable, you do it. I got no problem. So I am thankful to Mr. Rohan and Mr. other people who are my IT team, and we are thankful to them for making this a back help to us, and see that this webinar should be mostly attended people, and it should be very successful for that. I'm thankful to my field staff also, sir. Thank you very much, sir. Thank you.
Thank you, Gupta ji. Thank you, researchant. Thank you,
sir.
researchant team.
Thank you, sir. Thank you very
Giving
much.
us
Thank you,
this.
Gupta ji.
Thank you so much.
Thank you, sir. Thank you.
Thank you, audience.